Imagine you were facing a real legal situation. It didn't call for the mathematical application of law, but it required deep listening, empathy, and a human touch for your legal situation to be resolved. In this episode, we're going to dive into these principles. We're also going to be speaking about the human side of the role of judge, decision making, and much more. Why? Because we've got the amazing Kevin Bell, who spent 15 years as a Supreme Court judge with us on this episode. Kevin Bell was also a commissioner of the Yoorrook Justice Commission, and he's done much, much more in his work. And this is episode 109, and we're recording this one right here in November 2025. So if this is your first time listening, I hope you find something helpful or useful in what we're sharing in this episode today. If you're a returning listener, high five, high 10, welcome back. You're a legend. We love having you part of our Rolling Through Negotiations community. Before we jump into this episode, I'd like to acknowledge the traditional custodians of these lands. Let's pay our respects to elders past, present, and emerging. I'd also like to acknowledge the Kaurna peoples whose lands we're recording this episode from. Let's roll. Kevin, welcome to Rolling Through Negotiations.
Thank you, Matthew. I'm really glad to be here and to be talking with you.
I feel almost out of place saying, Kevin, welcome to Rolling Through Negotiations, because
Kevin's fine.
Given your legal experience as well. So I appreciate the humility that you bring as well, being able to address you by first name.
No, not at all. Years having lost my first name to an office, it's actually cool for me to be back as Kevin.
This is probably a very human question to ask. I think it kind of sits in the point of view of titles and terminology that's used in different offices, but sometimes we do need to remember the human side of things.
Mm-hmm.
As a person who is also a judge, what is it like? What's the lifestyle of a judge?
It would vary from person to person. There are certainly judges who manage to maintain an active personal, private, social, and other life. There are judges who are composers of music. There are judges who are writers of fiction. There are judges who are academics. There are judges who are winemakers. There are judges who have all sorts of different aspects to their lives, not to mention being partners in life to people and parents of children and so on and so forth. But there are many judges who don't engage themselves actively in other part of their lives and devote themselves almost completely to their work. I would think that traditionally most judges would fall into that latter category, particularly during the age that most judges were male, and the male work ethic was dominant in society. I think that kind of exclusive devotion to work gives rise to all sorts of emotional well-being issues, which are of concern to judicial institutions all over the world, and certainly Chief Justices in Australian institutions and me as the president of VCAT were concerned about that kind of overemphasis upon the work side of things. I think a lot of judges now sit in between the two poles, moving in the direction of more engagement with the general community. I've always had a diverse life, and so I lived on a vineyard most of the time I was a judge. In fact, all of the time I now recollect I was a judge and still do. I had other interests. I was an avid reader, a traveller, and of course a winemaker, which I did out of love for life itself, in addition to love for the law and the work that I was doing as a judge. and my wife Tricia and I shared those interests and still do. And so I really tried to be a better rounded human being, though a judge, and I hope I succeeded to some extent.
Yeah, it's interesting because one of the themes that we bring through Rolling Through Negotiations podcast is the way that principles of law, as well as legal excellence in practice of law and negotiations in the commercial context and business context and community context, can interrelate, and there's some similarity in principles with Brazilian Jiu-Jitsu, which is a martial art that I love, and we've had a lot of...
About which I know absolutely nothing.
Yeah. But what I think is really interesting is that if you look at some of the principles it takes to be successful in a area of life, say winemaking, there could be a commonality of those principles being applied in different contexts that bring about the same kinds of results. So
I strongly agree with that. For me, being a judge was not so different from being a winemaker in certain respects, because when you are a winemaker, I think you'll find this analogy forced, but I can assure you that in my mind it is not.
Okay.
When you are a winemaker, you are attempting to realise the inner potential of land through growing grapes and then manifesting those grapes in wine. And so you are bringing to bear a principle which is bigger than yourself. And yet you are adding something of value that only a human can add, which is the interpretation of the potential of the land and the manifestation of that by making wine. Now, when you and so you'll see that it's part bound by science, you might call the rule, and it's part bound by creativity, you might call the making. Now, being a judge is not so different, because you are bound by a body of rules. Indeed, not just bound by them. Your very function is to express them, to interpret them, and faithfully to apply them. And yet you have to bring human attributes of analysis and communication to bear in making the final result. And I always found fascinating that I felt I was a better judge for the winemaking and a better winemaker for the judge.
Awesome. That is a great example and something that sits within the ethos of Rolling Through Negotiations and the bridge that we draw between.
I'm glad to hear.
Yeah. It's interesting as well when you speak about the balance between the human element and the scientific element. And I once heard that a decision and a feeling and a result can be achieved through the feeling that somebody gets of another person, and the scientific application of law can sometimes follow that. I was wondering if that can happen, or if there are certain disciplines in place to make sure that we keep the scientific application of law at the forefront, and how does that all work out in your experience?
Let me tell you a story. So one day, I was in the practice court, and a woman with her daughter came into court. She was a woman of Greek origin. The case is a published case, and she has produced or participated in a podcast production on this case. So I'm free to talk about it, but out of respect for her and her daughter, I won't mention her name. She was a woman of Greek origin for whom English was a second language, and her daughter had a learning disability, which is really quite a serious disability to have. It meant that she, as an adult of about 30, she had the cognitive age of about 14 or maybe even less. They'd been over to the county court. Their application to set aside a judgment which resulted in the sale of their house was refused, so they couldn't challenge the judgment that their house be sold. Now, I listened to them with care and gave them lots of space within which to communicate to the court. They were unrepresented, of course. It was immediately obvious to me that the young woman concerned had serious difficulties in engaging with the court process, and I had to create a situation within which they were able to communicate effectively what their complaint about what happened in the county court was. Now, as a result of that, it became completely clear that they'd been treated in the county court as competent participants in a legal process, which they plainly were not. And the way that I treated them in court and enabled them to communicate with me as the judge was very much the product of what Indigenous people would call deep listening, which involves a certain discipline and respect for the other. And as a result of that, I was able to determine that they had their human rights and their rights to natural justice were breached in the court below, and this led to a setting aside of the judgment. There was a rehearing. They won the rehearing, and their house was not sold. Now, it had burnt down, incidentally, so they were never going to go back into it, but they would have lost a lot of money had it been sold. Now, one aspect of this I think is important is that I came to the conclusion that they were in a state of personal grief by reason of the burning down of the house, which was not so long ago at the time. And grief at a burning of a home is a well-known psychological response in the nature of post-traumatic stress disorder to such a thing. And I came to the view that their inability to communicate was partly informed or caused by that. Now, on that, what you might call personal foundation, this personal feeling aspect with which you opened this question, I was then able to turn to the application of scientific legal technique, which concerned judicial review, the grounds of judicial review, the application of human rights, which are, of course, rules and laws, to the setting as I was able to find it to be. And so what I would say to you, and why I suggest to you that the question you've asked is profound, is that you can't have one without the other. In many cases, I mean, there might be some cases where the human dimension is literally irrelevant. I'm thinking of some kind of tax cases which are just really about numbers and words. Although there's human beings behind the dispute, they're not really affecting the way the numbers and the words are dealt with in the case. But in this kind of case, and in so many others, there is a very strong human dimension which can be missed or misunderstood if the judge or the judicial process isn't sufficiently attuned. And when the judge or judicial process is attuned, then you can turn to the application of the objective laws to achieve the ends of justice.
Yeah, I think that's a great example. And I think that, I really appreciate you sharing that example with us. And I appreciate your humility in answering the question, because even as I asked the question, I felt like there was a little bit of being against the grain in answering and asking that question. And the reason for that is, I think that when you look at Law 101, it's almost like the integrity comes from the robotics in the application of the law. But the other way of looking at it is, well, if you don't have that connection with the human element, then how can you have the integrity in the application of the law? And so with the law and the human side coming together and the artistry of the application of the law being in the solution, I think that's probably where the skill set of a brilliant judge is vested.
Yep, maybe.
Kevin, you've done some also amazing work that we were speaking about in terms of the leadership and the impacts that you're a part of through the Yoorrook Justice Commission. And we have some listeners who are from Victoria, but some aren't. I think that we'd have a lot of listeners understand what the Yoorrook Justice Commission was all about, but not every listener would. So I was wondering if you could explain a little bit about the Yoorrook Justice Commission, but also in particular for our podcast listeners, what sort of negotiations take place through the Yoorrook Justice Commission process?
The Yoorrook Justice Commission is a truth and reconciliation and justice institution. It's a royal commission. It was formed because the First Peoples Assembly of Victoria determined that they did not wish to continue or enter into a treaty-making process without truth having been told about colonisation and the impact of colonisation upon First Peoples in Victoria, and about the continued injustices flowing from that impact. It was a very considered decision that was made by the First Peoples Assembly. The First Peoples Assembly is a representative body of the First Peoples in Victoria, numbering 30 plus, and including representatives from all of the peoples, groups, clans, however so called, of First Peoples organisations in Victoria. So it's a kind of black parliament, and is a decision-making body of really profound importance in Victoria because it's now being constituted as a representative body under legislation and as the partner to the government in treaties, one that has been made, a statewide framework treaty, and others to be made on a more localised basis. Truth-telling is a modern phenomena. It has happened in various places in the world where political, armed, social, ethnic, racist type conflict has occurred, including in the colonial setting. I won't give examples because that would take too much time and I think it's unnecessary, but I might reference Canada, South Africa, and other places. The Yoorrook is a very interesting example of a truth-telling body because it's well named. It's the Yoorrook Justice Commission. Yoorrook is Wamba Wamba language for truth. The Wamba Wamba are a people of north central Victoria. The distinguished chair of the commission is a Wamba Wamba woman, Eleanor Burke, and Auntie Eleanor represents through her language and her being the chair of the commission the principle of Aboriginal self-determination as represented in Yoorrook. It was a commission that was comprised of 4 out of 5 Indigenous people. 3 out of 5 of those were Victorian First Peoples, Auntie Eleanor, and the 2 deputy chairs, Travis Lovett and another chair whose name will come to me in a minute. And of course that is Sue Ann Hunter, originally Uncle Wayne Atkinson, but he was replaced by Travis Lovett. I was the only white person, and it was a very great privilege for me to be part of the commission. I was chosen by competitive application, as were all of the commissioners, and I was with the commission for nearly 3 years and rejoined the effort to bring truth and justice to bear after the commission produced its final report by promoting treaty making on the basis of the recommendations of the report. There's a lot to say about negotiating, in the context of an institution like a truth-telling commission, but I might leave you to ask specific questions about that to which I can respond.
Awesome. As you say that, Kevin, I feel like you would have seen many a time, witnesses putting back some questions back to the questioner. That just came to mind as you craftily and skillfully put the onus on me now to ask an intelligent question. As we go through this, so I think that a big part of the Yoorrook Justice Commission process would have included the listening, the healing, the self-determination, the recognition, the sovereignty principles that come through this, and so many benefits that probably have been experienced through some of the other jurisdictions like Canada and South Africa that you mentioned. A question specific to negotiations, now that you've given such a really clear understanding to us about the Yoorrook Justice Commission, is do you feel that truth-telling done right can lead to negotiating better futures for Aboriginal peoples?
Yeah, I do, but it's there are those who think not. Now, let me draw attention to the considered views of Les Malazar, whose views I also always listen to with extreme care. Les is a Queensland Indigenous person. He was the chair of the Indigenous caucus of the United Nations when the Declaration on the Rights of Indigenous Peoples was passed in 2007. No Indigenous person of the world was more influential than he, as an Australian Indigenous person, in that process. And I pay tribute to Uncle Les's role in that historic movement. Now, he has expressed the view on a number of occasions, publicly and to me personally, that there has to be a context for truth-telling for it to attract support as a mechanism. And he says that the mechanism has to be one that encompasses justice and transformation as outcomes. Now, there have been truth-telling processes in the world which have lacked those elements, and which have just produced documents which set out truth. I can think of a couple in my mind, but I prefer not to name them because I think the view would be contested by participants on the ground in those places. Now, Yoorrook it could not be more different to a process which was focused only on truth or facts or the past, because it was, after all, the Yoorrook Justice Commission, the Truth and Justice Commission. It had terms of reference which were perhaps the widest of any truth commission ever in the world, which were linked with rights, with transformation, with change, with the contemporary and ongoing impacts of the wrong that was done at colonisation, not just identifying what that wrong was. It was a mechanism that was requested, if not demanded, by Indigenous people themselves in the state of Victoria, which was populated by 4 out of 5 Indigenous people, 3 out of 5 First Peoples from Victoria, which was intended to lay the foundation for treaty making, which, after all, is the ultimate manifestation of self-determination, itself a political right in Undrid. And so it was by no means just one thing. And so I very much link the success of mechanisms like Yoorrook to the way that they address not just the past, but also the present and the future. The way that they don't just tell a new narrative about what occurred, which needs to be corrected, but to do so by reference to universal values, founding rights, against which the behaviour individuals can be judged, so as to bring accountability where there was impunity, and the way that institutions like Yoorrook and the more effective truth-telling bodies restore power, re-empower, transfer power to people who have been oppressed by historical processes into which the mechanism is inquiring. So from my point of view, Yoorrook, it's certainly in the way that in its purposes and its intention, and in the way that its founding document, the terms of reference in the letters patent were expressed, had this much broader remit, which I think made its work profound.
And I think that the success of attainment of better justice outcomes delivered through the process and deliverables of the Yoorrook Justice Commission will depend on the level of true change in justice that can occur as a result.
I really agree with that. I strongly agree with that. It's too early to tell just how effective it will be from the broader view of these broader objectives. How much transformation will there be? How much more and better will the rights of Indigenous peoples be respected? How much power will be transferred? How much substantive change in systems will be brought about? Health, housing, justice, land, others. Will educational outcomes and health and wellness outcomes for First Peoples be significantly improved by reason of what's occurred? All of these things I might describe as necessary substantive changes, one kind or another. How much substantive change will occur? I think it's too early to tell. One substantive change has occurred, which is absolutely remarkable and to be celebrated, which is the creation, which we recommended, of the First Peoples Assembly of Victoria as a representative body to speak for First Peoples in Victoria, and for the treaty making process to be legislated and enacted on. And the government has delivered in that regard, and that's a really significant outcome which I celebrate and applaud. But it's a substantive change of a political nature. It does not directly and of itself lead to these other changes, though I expect that it will and hope that it will. And when changes in the nature of health, in housing, in justice and these other things occur, then we will be able to say with more confidence that Yoorrook didn't just speak truth, but caused action upon injustice to occur in a way that was truly substantive.
Yeah, and I think that the work of the Yoorrook Justice Commission so far that I'm aware of in terms of the gathering of information process and the listening process in which that information was gathered for reports to then be produced, really most of the work being about the information gathering and the collation into reports of that information, I think is a principle and process that needs to happen whenever negotiations are done well. Because we always need to be in the place of listening, no matter the level of the negotiation. It could be a negotiation with our wife at the dinner table, but we need to be able to properly listen to the other party's perspective, to be able to put that information together and then use that information through proper application with proper values like integrity, like justice, like fairness, all being in place to achieve better outcomes. And if that happens and if the information is used in the right ways, then I believe that the work of the Yoorrook Justice Commission can lead to some positive outcomes. If it isn't used in the right way.
I can give you two examples where that's not happened.
Yes.
So if you look at the if you look at the way in which people living with mental illness are treated in this country and have been historically, you will find that they have been treated really badly, many of them locked up, keys thrown away, subjected to incarceration without just cause in institutions. Many have not been provided with the healthcare treatment and support that they really need. Many subjected to compulsory treatment. Some in significant numbers subjected to electric shock treatment. And this has happened on an institutional scale that's has given cause to shock and concern within the community. It's literally shocked the public conscience of the nation. It is so bad, and has been the concern of departments of state, policymakers, NGOs, caring organisations, various institutions with which I'm working over a long period of time. Now, you can ask yourself, how do you frame that problem? And the current framing of the problem is, in my view, way too narrow and doesn't allow you to really reach what's occurred and what should be done to fix it. It's being conceived not in terms of justice, of treatment by one human of another, being framed not in terms of human rights, being framed not in terms of obligation. It's been framed not in terms of recognition and redemption, which are moral concepts. It's been framed. The problem's being framed differently to the way it has been in the past, which is a very good thing. And we're moving from paternalism to respect for equal dignity, which is a very good thing. But not in any way is it being framed like Yoorrook was framed, which is that there has been a very great wrong done by human beings to others, which involve conceptions of moral responsibility, travelling forward in time, which need to be recognised for there to be a kind of reconciliation. And I think there does need to be a kind of reconciliation between people living with mental illness and the broader community. That involves the broader community accepting a kind of responsibility for the treatment. And so you can see that I'm advocating, I'm really contrasting here what occurred with Yoorrook, which involved all of these broader moral and other conceptions which were necessary for the process to be authentic, with another kind of process which is more bounded, much more qualified, and doesn't enable us to reach the heights of understanding and then acting on the understanding if the problem were differently framed. Now there are other examples I could give. I think the way that religious institutions exploited and abused young people and even some older people is another example. The Royal Commission played a like role there. That was more a truth obtaining commission, and is perhaps much closer to the idea. So I'm very much of the view that there are some things that are so wrong in a systemic way that you need to approach them much more broadly than other things. And what occurred to First Peoples in Victoria is perhaps the strongest and best case of that.
Yes, and sometimes we need to be able to step into the past to empathise, build bridges, connect, appropriate wrongdoing as part of a forgiveness process before we can start stepping forwards. And I feel like sometimes if we gloss over the destruction and devastating facts of the past, then the future can never properly be healed. I think this is also...
Agree, yep.
And I think this is also really interesting when we look at the very recent treaty that was made in Victoria for Aboriginal peoples and Aboriginal communities in Victoria, because I feel like, on the one hand, and overall, it's a fantastic achievement.
Yeah.
I feel like the step forward in recognition through treaty making, the process that involves the self-recognition and the reconciliation that is brought, is all coming forwards in a spirit of positivity through the process. And I also think that it's got great potential to be a motivation for other Aboriginal peoples in the various states to be able to knock on the doors of their own state governments and say, hey, let's follow the footsteps of what's occurred in Victoria. So overall, I think it's a great achievement. But I also feel that there's a fundamental downfall in the treaty process, in that it's all been made through mainstream legislation. It hasn't been made in the recognition of the sovereignty of the Aboriginal peoples of Victoria, but instead it's been done as a process of state that doesn't recognise the sovereignty.
This is an interesting problem, and one that the First Peoples Assembly have had to grasp with, and their solution has been to enter into a process made under the law of the coloniser, but in a way which recognises that they have never ceded sovereignty themselves. And so, given, and some would say that because the state of Australia is represented at the federal level by the Commonwealth, short of there being recognition of sovereignty in the state, in the Commonwealth Constitution, Indigenous peoples should never enter into a treaty. Now that view has been rejected by the vast preponderance of opinion within Indigenous communities. I am confident. Now, coming back to Victoria, of which I have actual knowledge, the First Peoples Assembly have decided in a considered way that for them to enter into a treaty, even under the coloniser's law, is an act of self-determination. And that act of self-determination has to come from the collective sovereignty which they never ceded. And for them, therefore, there is no dissonance. There's no conflict between that ancient land-based sacred trust which they hold and which they call sovereignty on the one hand, and agreeing to facilitation legislation through which treaty making is able to be achieved. But I guess if you ask them, they'd say if there was some other way that was more sovereignty friendly, then they would like to have it. I do note that the legislation doesn't expressly say that the state of Victoria makes this treaty with the representative of the sovereign Aboriginal nations, which would have been an even stronger affirmation of their political position, which in my own view is absolutely undoubted. But it does say very explicitly that they have never ceded sovereignty. Sometimes the language is the First Peoples of Victoria assert that they have never ceded sovereignty, which is a kind of soft way of accepting that. At other times, the official language is more definite. The First Peoples of Victoria have never ceded sovereignty. Now, that's a stronger way. There are even stronger ways of putting it, as I've suggested. But I accept the resolution of this important problem which the self-determining bodies themselves have accepted, and that's the one that I've described. Now, I want to say something about native title in this context, which I think is helpful, because Mabo and its historical and international antecedents. Mabo comes down from and in the context of international law, and of course is reflected in the native title legislation. It stands for the proposition that where there is a continuing landholding community observing traditional law and custom, maintaining its connection with land, then it is the traditional owner under Australian law of that land. Now, it's Mabo, the international law and the native title legislation describes a landholding community in that way, but a landholding community which is defined by reference to its connection with land through the observance of traditional laws and customs as between the people with respect to that land, also necessarily implies the existence of a political community, and that political community is a group sovereign, that's to say a nation, a group of people with political rights inter se, who are sovereign with respect to each other and that land. And so that's the way that I look at it, and I believe that the resolution by the First Peoples Assembly is a practical and principled way of dealing with this fundamental problem, and they have definitely gained in terms of recognition of sovereignty, the approach that they have adopted, and have not gone backwards in that respect, in my view.
Awesome. I appreciate the extra level of detail in some of those things you've said there, Kevin, that perhaps we haven't all thought of to that degree. So appreciate that insight as well. I've got a couple of questions for you before we wrap this episode up.
Mm-hmm.
The penultimate question, I think, is one that our listeners would be upset if I didn't at least ask you something about. Because you've been so instrumental in terms of the Victorian Charter of Human Rights and Responsibilities.
Yeah.
I'm going to ask you a wide question on this to have the creative freedom of being able to listen to your response.
Yeah.
How can the principles from the Victorian Charter of Human Rights and Responsibilities Act 2006, which is Victorian legislation, help people negotiate better lives, particularly where there's power imbalances?
The Charter is intended to reorder relationships between citizen and the state, to a certain extent between citizens and other citizens, but let's focus on the relationship between citizen and the state for the purposes of your question. You have situations where people might be the subject of state power in circumstances where they're vulnerable to abuse and exploitation. Now, I've been concerned with that problem in several different settings. I've been concerned with that problem in the judicial setting, the relationship between a court and an unrepresented person. I've been concerned with the problem in the housing setting, the relationship between a public housing tenant and the government department administering the system, the Housing Commission. And I've been concerned in several cases with that problem in the context of people living with mental illness and their treaters, psychiatrists, hospitals, and so on. Now, focusing on the latter, because the Charter reconstitutes the person living with mental illness as a subject and holder of rights rather than a welfare recipient. At the legal level, at least, a different kind of treatment is required by those exercising power over them, the doctor, the hospital, the tribunal, or whatever. And so this most definitely enables them to negotiate for a different outcome than might have been imposed on them under the earlier paternalistic regime, with which human rights is utterly incompatible. It doesn't do that just by creating a different relation of legal power. It does that by creating a different way of understanding the people concerned. So we have to understand differently a person living with mental illness, not as someone who is defined comprehensively only by that thing, that is their condition of illness, but as a person who has equal dignity with everybody else, who is living with that thing, that illness, which is a completely different way of understanding them. It's the difference between treating someone as personally defined only by their illness, on the one hand, and treating someone as possessing equal dignity, but who may be in need of some kind of treatment on the other. So I give you that example as a way that the Charter and rights really do affect the way that people can negotiate through their lives. I am a carer of a son who's living with mental illness, and this fact that his views and preferences as to whether to seek treatment, what kind of treatment to accept and when to accept it, is ever present in my mind, and our negotiations with each other concerning this subject, if negotiations be the right way to describe them, are personally affected from my point of view by this very issue. Now, regrettably, the Charter is not universally understood within the Victorian government. There's widespread violation of its requirements, particularly as regards First Peoples. Sometimes these violations are really serious and give rise to death. I'm not talking about an intentional death, but deaths in which, as found by the coroner, violation of human rights or non-fulfilment of human rights has created circumstances in which people have died. So it's not all beer and skittles in the state of Victoria, I'm afraid. But in those cases where the Charter has been claimed by people affected, and they have been assisted to take their claims forward, there have been really, really strong results in their favour.
Awesome. Thank you for sharing that as well, Kevin, and also your intimate understanding with some of these principles, including through your role as carer for your son. We've been able to touch on just some of the experiences and wisdoms through negotiations you've been a part of in various platforms and work that you've done throughout your amazing career, Kevin. The final thing I'd like to ask is, from all the different contexts, from all the different places that you've been a part of, the workings, you've been a part of the negotiations, the instrumental change that you've seen taking place, if in this moment you had to describe the cornerstone principle for negotiating positive change, what would that cornerstone principle look like? What would it be?
for negotiating change.
Yes. In
I
positive
think I would
ways.
say I think I would say be just and fear not.
Mm. Beautiful. Be just and fear not. That could be a almost like something we get for our mantelpiece on some beautiful stone or something. Be just and fear not. Few words, but very powerful. Kevin, thank you for being on Rolling Through Negotiations podcast. Your work, your career, and what you continue to do, your passion for Aboriginal peoples in community, for seeing just outcomes for minority groups and for disadvantaged peoples in the variety of ways, I think is inspiring, it's powerful, and really appreciate having allies just like you on this journey. So it's been great connecting with you today.
Thank you, Matthew, and congratulations on your own work. I'm an admirer and a fan. May the force be with you.
May the force be with you.
And fear not.
Thank you very much, Kevin. And guys listening, and remember, if you've liked this episode, press that like button for the podcast. Share this one with your friends. Subscribe and follow Rolling Through Negotiations. Because if you do, we can keep on bringing you more great episodes just like this one. Us.